Okay, and greetings everybody. Keith here. Hoping everybody's having a good day, enjoying life and living life and loving life. I want to remind everybody hit that like, share, and subscribe. There's a PayPal link down there for anybody who wants to share some love. And of course, the StreamYard link is down there for anybody who wants to join the panel. And we've got John with us again tonight. How you doing tonight, John?
I'm doing good, Keith. How you doing?
Good. Good,
Yeah.
good. Enjoying the nice weather still. Had another great day outside.
Oh, okay.
Um,
Yeah, these shows are really penetrating. So, I mean, what I meant by the headache comment was that this is a good headache. This is like a exercise for the mind, and
exactly.
I wouldn't be here if I didn't enjoy it.
Well, I appreciate that. I really do. Let me get my machine set up here, guys. I always try to make sure I use my wave frequency generator here throughout the course of the day, and just haven't done it yet. Sorry about that. So, in the meantime, what we're going to do tonight is we're going to continue on with the subject from last night, which was real party and interest. And tonight we're going to talk about the real party and interest through a Washington law review. So, we're going to dig into it here right away. Um, the real party, excuse me, not Washington. I'll have to change the title. I was sure it was Washington. It's Kentucky Law Journal, Volume 10, Issue 2, Article 4 from 1922. The Real Party and Interest, Lewis M. Symes, University of Montana. And it says, let me blow this up just a little bit more. Says the real party and interest, Lewis M. Symes, University of Montana Law School, Missoula, Montana. Says every action must be prosecuted in the name of the real party and interest, as it's been reiterated several times last night. This familiar statute appears in the so-called Reform Codes of Procedure of nearly 30 states. And this is 1922, so now it's incorporated through all states. Equality of the law among states. Article 4, I believe it's Section 4. And in spite of its simple conservative character, nearly three-quarters of a century of judicial interpretation and textbook exposition have given it such varied and diverse meanings, and in some cases have attributed to it such revolutionary results as to make a consideration of its real import altogether pertinent. This goes to the aspect that the identification of the party must be so discerned that there is no mistake. A glance, and this goes to the various different styles that they use. If you look up my or the criminal and civil files on the Keith Little here in Waterloo, Iowa, it will show you the different styles that it uses throughout that record. That's showing that there's multiple styles. It's showing that they switch jurisdictions, and it tells you which jurisdictions use what styles. A glance at a few authorities will show this diversity. Some have clearly taken the ground that this provision changes substantive law. In speaking of its effect on the assignment of choses in action, this is your choice on your actions. One writer says, it would seem that the property of the assignee is now strictly legal, and therefore it pertains to the entitlement, the entity, the title itself, which is the name of the estate. The estate is Keith Orland Little in all uppercase, or Little Keith Orland in all uppercase. They both represent the estate, while Keith Little in the upper and lower case letters as a first and last name represent the legal representative, the trustee. Another, speaking of certain decisions on this statute, uses these words. This, of course, departs from the common law and is another example of a change of substantive law due in part at least to the code provision referred to. In other words, like I said, these codes are deemed to be equitable and therefore are a reference to an equitable solution. That's it. They're not laws. Others have expressed the view that this section affects only procedure. Wrong. It affects the access to the proper procedure. This is your choice of law, your chose in action. UCC 1-3 or 1-103, I think. I'll have to look that up. But it talks about your several and joint liabilities as well as your choice in law. See, the plaintiff has a choice in the law, the choice of the jurisdiction. This is why it's required to bring a cross-claim or a counterclaim so that you can present the superior jurisdiction, equity.
And equity is our ability to create a remedy, right, Keith?
Correct, because there's a mistake, and the codes do not allow for a remedy in your position under common law for a benefactor. It only allows remedy for trustees, those corporate contractors, those of incorporated capacity organized under the laws of the United States. A common statement in the decisions, particularly the early ones, is that the real party in interest is one having the equitable interest of title. An equally common statement is that he is the one who has the legal title. An equally common statement is that he is the one who has legal title. However, under trust law, if the beneficiary, who is the one that has equitable interest, holds the legal title, like I've said before, he is the one that can perfect that title. In perfecting that title, it collapses the trust. This is why we have to think about irrevocable and revocable trust. They operate in different manners. An irrevocable trust is pertaining to the assets only in transfer to next generations repetitively. The revocable trust is for such actions here where a beneficiary can come up and settle the trust. And once the trust is settled, it's now collapsed. It's completed its purpose. And then it goes on and talks about things down here. One of the things I want to mention is right here. It talks about Pomeroy's Code Remedies, 3rd edition, section 124. So I'll be looking that one up too. And somebody earlier sent me a email with some clips of Rourke on equity. And I've done, like I said, my own research on equity, and that's what brings me to this trust law and how to express the trust and your position in the trust. I've been on several calls with Rourke himself discussing these very points, and that's why I do this. I think it's very important to understand the various different grammars that they use through contracts and trusts that switch the jurisdictions. Again, Isaiah 54:17, no tongue shall prosper against you, and you shall rise up against anyone that places that judgment, because that's a false judgment. That's a judgment in person. And he's no respecter of persons. That says if you're counseling in God, or that immutable promise to seek his counsel, then you're supposed to rightly divide the word of truth and not be ashamed about it. The real party in interest, we even find such loose expressions as this. The real party in interest is the one who is to be benefited by the judgment in the case. On the other hand, it has been said, and with entire accuracy it would seem, that a party to be interested in an action need not be the one who may gain or lose something therein. Gain or lose something therein. Those are different terms than benefit. See, the beneficiary is not required to do anything. That means there's not an equal exchange, and it remains in its capacity as a gift and not an equal exchange where there's an agreement of a value system. See, a simple trust goes from a grantee to a beneficiary without the need for a trustee, and it exists without a contract. But a contract is evidence of a trust incorporating the capacity of a trustee, saying that they are holder of an asset that is supposed to be only invested for the benefit of the beneficiary, while they can benefit from that transaction by their percentage of pay on the investment itself. That's it. They're not supposed to go after the estate, only investment in the state that they have a monetary interest in, where they are not the real party in interest. As a suggested resolution of the difficulties involved in this piece of legislation, we submit that it should be interpreted to mean simply this: that the party to whom the substantive law of the case gives the right to bring and control the action must sue in his own name. The beneficiary is deemed to be the true owner in equity. Equity imputes that the beneficiary is the true owner, and the true owner can come forth and settle the trust estate matters, despite the fact that there is or is not a trustee. If there is a trustee, he has the ability to dismiss that trustee, and his best ability to do so is to prove misfeasance or malfeasance or both. Executor des tort, administrating a probated estate in a matter of a trust capacity as a trustee under public service contracts, and is incompetent, negligent, or intentionally, willfully creating and causing harm, damage, and injury to the very one that is supposed to benefit and is known as the real party in interest. For convenience and discussion, this rule may be divided into three parts. The real party in interest is the one to whom the substantive law of the case gives the right to bring and control the action. Again, that's equity. And your admission into equity is through common law, not the administrative codes. The real party of interest must sue. The real party in interest must sue in his own name. And is submitted that only the third part of the rule represents any innovation. The real party in interest must sue in his own name, and that is the only part, the third part, that represents any innovation. This is the enumeration at birth, where the novation was created of the legal name. That's known as a novation. It's a novel creation. And they're creating a journal similar to a novel. Who is the real party? A record, and records maintained on an individual. Who is the real party in interest is not a question of the law of parties or procedure at all. You cannot answer it that way. It is simply a matter of determining the person whom the substantive law of the case gives the right to sue and control the action, the choose in action. Again, your choice of law as a plaintiff. If you are suing in a court of law, the real party in interest will ordinarily be the man who has the legal right, not because the holder of a legal right is necessarily or always the real party in interest, but because as a rule, the branch of the substantive law under which you are suing gives the holder of the legal title the right to control the suit. So I hope you understand, as the holder of the legal title, like I said in earlier video today, the birth certificate is a document of title. That name is in all uppercase, and the second name on the certificate is the beneficiary. That's in their codes. It's telling you the second name is the beneficiary, and it's in a title form. The grammatical style is a title. That's the entity, the entitlement. The legal name is the representative signing as authorized for the estate. So you sue in the all upper caps name. Admiralty side would be last name first, or last name, comma, first and middle, all uppercase. And then you would sign as benefactor, settler, dismissing the trustee. He can no longer administrate the estate. He is only a cooperative as a conservator. In other words, he's not supposed to add on to the record, but he's supposed to conserve the record as it is so the investigation can be done. In other words, there's an halt, a estoppel. There's something wrong with the record. It needs to be investigated. And that's his duty as a conservator, to conserve the record so that we can go back and reflect upon the errors and fill in those errors with the supplemental truths that would qualify it as a contract or dismiss it as a contract for its impossibilities and prove the only capacity left is benefactor. Go ahead, John.
It starts under the census, right, Keith, as an appointment, the
Correct.
BC.
Assignment.
Yeah, and appointment too, but it's a false appointment, I think.
Correct. There's no power of attorney. Mom didn't actually sign over a power of attorney. That was a presumption, only because there isn't an existing power of attorney recorded saying that they own the estate and nobody else can administrate it under Scott versus McNeil. He's still alive and well. We're keeping an eye on him, not as parents, but as his earthly mom and dad, and he recognizes the one Father which art in heaven. That's his counsel, as we are training him up in that counsel, so that he shall not waver when he becomes age of majority, and he does not have to listen to your notices. Notice. That means no temptation. He will not be tempted. And that's what these are. They're all temptations to take upon a benefit that isn't a benefit, unless you qualify it as a benefit yourself, knowing that you are the real party of interest and can express it as such. And this has to do with the different styles. Express it in the estate name, qualify it with your signature in the first and last name with a notation, an added notation without recourse, without prejudice, by benefactor for the estate as settler, done in good faith with patent right. An extension of credit.
So,
all glory goes to him. Go ahead, John.
okay, so we have to organize it, right, Keith, and appoint interest.
Correct. And that's simply, like I said, letting them know that somebody else has an obligatory interest under 18 U.S.C. 8, obligations and other securities of the United States for stamps and other representations or representatives of value. What is the unpaid balance of money or its equivalent? Its equivalent is a representation of value known as credits, whereas they're obligated to give credits if they haven't already given those credits. That's an extension of credits only. Giving freely what was freely given. On the other hand, if you come into a court of equity and state a cause of action which can exist only in favor of one having an equitable interest, then the holder of the equitable title is the real party in interest. Not because there is any rule that the real party in interest is the holder of the equitable title, but because the substantive law under which you are suing gives the right of action to the holder of an equitable interest. The test of whether one is the real party in interest with the meaning or within the meaning of the statute, say some of the best authorities, is does he satisfy the call for the person who has the right to control and receive the fruits of the litigation? Does he satisfy the call? I do not have an identification. Well, what's your name? Sorry, I don't have a name. but I do have a calling for the person. That's a call for the person. Like I've said before, English is very simple if you use the simple terms. Does he satisfy the call for the person? Why do you think they call out the name of the person? Because they want to know if you satisfy it. And once you satisfy it and you don't clarify that you know and can distinguish and discern that you are in fact the real party in interest, and therefore in equity, you as holder of the certificate in your hand, the document of title, with the very title on it, are the very living soul in which the person was extended from, and now it has returned back. Hallelujah for circulation. Who has the right to control and receive the fruits of the litigation. Again, this goes to the investment, the fact that you're the principal and you're not receiving the fruits of the litigation and are taking upon the detriment as surety of the defendant. When the defendant is a complete abstract noun and cannot be sentenced to jail. I mean, you can sentence it to jail and put it in that cell, and I guarantee you it cannot starve, and you have no need for a budget to feed, nor water, nor provide it with soap, shampoo, toothbrush, or even a fucking toilet or a bed. Having defined the real party in interest, our next proposition is that he must sue. Now, there is nothing new about that rule. From the time immemorial, courts both of law and equity required the person who had the substantive right to sue on it. This is the Seventh Amendment. Sixth and Seventh, excuse me. We think a case cannot be found decided in a court of law, says a court in a jurisdiction whose laws are unencumbered by the real party and interest statute, where a person having no legal interest in the subject matter of the action has been allowed to maintain an action at law alone or with others. This is your third party debt collectors in all cases, with the courts ensuing that debt collection through a court registry investment system wherein they benefit based upon abandonment because you didn't know what was going on, and they do. So it comes back with no principle. When they know damn good and well through that conversion, they are not the principal. They are the trustee, and therefore they got the information, the data elements from someone else, conducting themselves as if though they're the trustee, namely a prosecutor or a district attorney or some other lawyer or attorney entering those documents to be filed into the public record and maintained on an individual, an investment firm. It is impossible that he consents by his own showing he has nothing for which to sue. Third-party debt collectors have nothing for which they can sue because they bought the debt for pennies on the dollar and are claiming that somehow because of their investment in that supposed debt that they could bet that the guy they were going to collect against it wouldn't know this stuff. See, they have no loss, harm, damage, or injury which they can file a suit to which relief can be had. Federal Rules of Civil Procedure 12B, Rule 12C, 12B6. Again, I purport to use all of the elements of Rule 12B. They have no standing on any of the elements, not just the fact that they can't provide a thing for relief because they deserve no relief. showing nothing for which to sue. He suffered no loss, and he can't use his investment as a loss simply because he was stupid enough to make a bad bet in a game of gambling against somebody else's intellect. Indeed, the conclusion of the court seems quite obvious, and in fact, in the very nature of things, it is difficult to conceive any system of law where the rule would be otherwise. Courts of equity have uniformly laid down the rule that suits must be maintained by the real party in interest. The federal equity rules have codified this provision in almost the precise language of the Reformed Codes of Procedure. Indeed, it is clear that the code makers believed that they were borrowing a rule of equity pleading. You see where the equity merges with common law? The code makers, they don't make law, they make codes. Article 1, Section 8 again speaks about the government and the rules thereof being made by Congress. They don't make laws, they make rules. They make codes, they make policies, they make procedures. Whereas equity is what is done is what ought be done. There is nothing new under the sun unless you know exactly who it is that you're identifying. Then there might be a discrepancy. If there's that discrepancy and you harm the one that you're suing against because you didn't have interest in that entitlement, goodness gracious, you might be found in violation of civil rights and common law rights in the court of equity and bringing claims which you have no expectation of relief. On the other hand, we find a similar rule laid down for courts of law. The general rule is, says Chitty, that the action should be brought in the name of the party whose legal right has been affected. Whose legal right has been affected. Not your legal choice in action. You don't have a choice in action unless you have a right to sue. And that right to sue means you have a right to sue in your own name because you were caused harm, damage, or injury. And if you think that by investing in a gamble that you can purport that you suffered loss, that would only be because of your own stupidity of not knowing where the true interest lies, and it never lies in a fiction. That is only a representation through the courts of law of what actually exists in equity, your choice. And see, that has nothing to do with the name. It has to do with the message. What choice are you going to make as to what message you are going to follow? Are you going to follow the message of our Father which art in heaven, or the false patronymical, patriotic, national laws that say you're subject under this public trust as a trustee? You're not. That's the fiction. Evidently, the real party in interest rule changed no substantive law. Its changes were purely procedural. Were merely procedural. The procedural part was the language. You use one language for this procedure, you use another language for this procedure. See, there are terms that you use in trust law, there are terms that you use in contract law, there are terms that you use in concise English that have absolutely nothing to do with contract or trust law. They're just plain language for common speech. You know, First Amendment, freedom of religion, freedom of speech, freedom of the press, freedom to assemble, and the right to petition the government for redress of grievances. And that redress of grievance is their indoctrination into Babylonianized text, thinking that somehow I have to follow that message. Sorry, not going to do it. Wrong procedure. If everybody's following that procedure and I'm going the other direction, it doesn't mean that procedure is correct. Maybe the one going the other way is correct. You never know. Because I'm certainly not going to jump off that bridge just because just because 98 people out of 100 jumped doesn't mean it's right. That's the ignorance of following this false law, is thinking that you know it, like a lot of these police do, and they don't.
I have my own definition of law, Keith. It's called
Go ahead.
legislatures at war.
Yep,
Think about it.
absolutely. They're contradicting each other. The war is the battle of the forms, where they're trying to use different grammar against each other because they themselves don't understand the jurisdictional venues. Absolutely. Want to give a shout out to all the supporters down there. Feel free to hit that panel link and join us. We've got Leslie Joe down there, Disciple of Messiah, Roz Blackwood. Greetings, everybody. We've got John on the panel, and we just got Rebel Studios up here. How you doing, brother?
Hey man, the word adultery. I kind of thought yesterday or the other day that the word adult would come from the word adultery, or vice versa.
Absolutely, that's what it's about. You remember the scripture, the mind of man is a commercial thing, and that's what adult is. See, I'm not adult, I'm not an parent, I'm a child of God at all times. In this world, I'm a child of my mom and dad at all times. As long as they are alive, I'm a child of mom and dad. Doesn't matter that they're 70, 80 years old. I'm still a child to them. I'm still their child, still a child of God. When we start thinking that we're the adult and we can start managing all these commercial affairs and we drop the spirituality, that's the adultery. We're mixing our spirituality with the manual form of existing in life. We're supposed to have a natural bridge there. So we've forgotten that natural bridge of our instincts and intuition, and we're using the manual system as if though we understand it well enough that we can operate in our adult lives. And again, that's the sadness I see, that people coming out of these high schools, a lot of them tend not to pick up another book or think that they need to learn anything. A large part of society believes that that seventh or eighth grade average reading comprehension is good enough to get them through the rest of life. And it's just not so. We have to remain that child and ever willing to learn. I think that's the problem. So, great point. Goes on to say, and it is believed that all that was intended was to abolish certain technical rules, such as those providing for a use plaintiff in case of suit by the assignee of a chosen action. So what they're saying here is literally, you can't get equity in an administrative procedure under a trust because all of the trustees are operating under that administration, unless you bring it in a contract form as a chose of action to contractually bind them to their contract. And this is why I say there is no power of attorney, in fact, out there. They're not actually obligated until you assert it. They're operating on a delegation of powers that allows them to presume their discernment. Go ahead.
Trustee would be like trust me, because you put your trust in someone else. Trust me to
Correct.
do what you want done. When even though you can do it yourself. So
Right.
unless you're mentally ill or incapable by physical means.
Correct. And that's why I say it's important to unlearn what you've learned and relearn concise English. And because of that, you can learn the different languages, the different grammar styles that are being used, and do that correction. Otherwise, these people won't do it. They don't have the competency yet because they They only do their job. And again, that's inherently why it's important, so important for people to start taking on the responsibility of learning this stuff, because nobody else will teach you. And this is exactly what's being used against you, knowingly or unknowingly. Again, they're just doing their job, and it's being used against you through a system of indoctrination where they don't know that they're actually violating you, when in fact, in their heart, they should. They're missing that moral concept, and they're just doing their jobs. In other words, the real party, or whereas the real party in interest always has and always must sue, he has not always been required to sue in his own name. That's where the common law merged with equity, because now you sue in your own name, and that's proving that you're the only one that can perfect that title, and that's the name that you're suing in, is the entitled name of the estate. You have to sue in the name of the estate, which is the real party of interest, which is the commercial go-between between that administrative code and equity, which is the common law. You have the right to present yourself. Your yea is your yea, your nay is your nay. That is not me. I know the difference. That is a United States business known as a United States citizen, and it was determined as a resident without the proper consideration. So when we go back and investigate the record and give it that proper consideration, which is looking back and making that actual discernment and filling in those gaps, we find out it's an impossibility. Nobody but the actual living soul under common law can make the claim of real party and interest, except the one who has the same name, entitled. By codes, however, he must now sue in his own name. That means you have to make that contract for the acquisition so you can get that title and hand it over to the right person that's supposed to hold that title. The administrative court holding it says that they're holding it for you because you're under administration. Whereas if you make your own declaration at the international level and that title gets passed according to expenses incidental to transfer title, you're the one making the transfer, showing that there aren't any taxes required to be paid, because nobody else has authority to transfer any capital, which is known as assets. My yea is my yea, my nay is my nay. Who the hell are you? Anything I use in my possession is mine to use. That is very clear. Go ahead.
Is this like clear title of record, Keith, where
Correct.
you have like an indefeasible or unencumbered estate?
Correct. And this again relates to Scott versus McNeil. Shows that the error of the state is not based in any kind of infraction of the law, but rather the misinterpretation and the errors that were put into the record because of the man that has the real interest in the estate of which it comes from. It is a derivative of himself, and it is only his misinterpretation and entrance of the data elements into that record that caused any errors. Now that can be realized and corrected, it shows the impossibilities of being able to correct the record fully as a resident doing business and permitted to do so, organized under the laws of the United States, because it hasn't occurred yet. If it can, he will work towards that, but it shows that it can't. He has to take on the official title of performing the function of public office. He's not qualified. All the offices are filled. So it continues on, and it says, this is indeed a slight novation. That was the novation of merging equity with common law. But its effect can hardly be of more consequence than if the legislator were to pass a statute requiring all persons to sue in their Christian name instead of their surnames. The same person controls the suit as before, but in furtherance of simplicity, he now always sues in his own name. It must be admitted that some of the courts have not interpreted the real party and interest statute in any such simple conservative manner. You have to be the one conservative. That's why I talked about the conservator. You have to bring the supplemental facts and hand them to him as an obligation, assigning him as conservator to transfer the title, expenses incidental, as a matter of investigation and correction of the records only. But in furtherance of the simplicity, he now always sues in his own name. It must be admitted, but it is submitted that the confused state of the authorities is due to two things. Courts have proceeded under the erroneous assumption that they could decide who was the real party in interest by rule of procedure. Reading between the lines, this is now telling us it has been determined that that is an assumption, and that assumption would be wrong. That the court could proceed under erroneous assumption that they could decide who was the real party in interest by a rule of procedure. This is the violation of my yea is my yea, my nay is my nay. Very simply. Thus, they have defined and redefined the real party in interest when they should have been deciding whether the law of chose in action gives any substantive rights to a man who takes an action for collection only, or whether the law of agents gives a right of action to an agent with reference to his principal's property in his possession. That's why we ask the credit collector, the debt collector, acting as creditor, trying to collect credits based upon a debtor. That's why we ask him for the documentary evidence of the underlying obligation. He doesn't have it. How do I know? Because I've got it in my possession, both for my companion and myself. I've got 3 of them for myself. That's that certificate with the real party of interest in real party in interest in the instrument. And it says that the state is the one that is the trustee, and the second name on the instrument is the beneficiary. So who the fuck is this third-party debt collector, and why are they using the state courts to come after somebody that is not a trustee? See, that's part of the problem. If the debt collector brings it in the name of the state, then they're proclaiming that the state is the real party in interest, and it was not named as the defendant or the plaintiff. The third-party debt collector was. But yet they're bringing it in the state courts. See the problem with that? Nobody's distinguishing who the real party in interest in is, and they're proceeding under that assumption, which is erroneous because they go by administrative procedure. See, to this day, they're still refusing to recognize this because it's you that has to go in there and tell them this. 2. Go ahead.
Yeah, people don't know that we live in the Republic of America. You know, we don't live in this imaginary United States of America incorporated corporation.
Yeah, that's part of the problem. That's why I'm trying to explain to everybody that U.S. citizenship that was conference of a nationality upon birth, that's got to be resolved. People have to start educating each other about this so that they know exactly what's happening in that hospital so they can prevent it or use it as an institution so that if they want to raise their child up to become one of the elected officials, they can do so by teaching them that. But if they don't want to bring them up in that civil venue, they still have to have they still have to have that knowledge in order to hold on, brother. Yeah, there you go. They still have to have you still have to have that knowledge to pass on, so that they don't get entangled in that web. So that they want to learn how to make their yay and their nay. They can do their own private trust grants and exchanges and contracts on the private side. It ain't nobody else's business. It's not a probated estate. And that's the problem. You have to file a suit in your own name, the real party in interest, because it's a probated estate. And that filing of suit is a declaration that the living man has now come forth, and the court of probates have no jurisdiction to administrate the estate of a person who is in fact alive. I'm taking over now. You have no authority. Go ahead, brother.
Yeah, I've heard that they force people to sign that birth certificate and tell them, we'll take your child. Your child can't do this and that, can't get benefits, can't work, can't do nothing, because they're not even told. And people don't know that they can go outside of it with either patenting your name or changing your name somehow, one letter, add two letters or more, one or two letters, to take you away from your original name. So that way you're no longer attached to the all caps and the Social Security, because your name no longer matches those names, even a passport,
Correct.
And you write everything in lowercase, everything, address, all of it. Or unless you want to use a P.O. box, which is probably safer.
Well, and that's the distinction again. We're clarifying the different grammar styles. And that's the important thing. Like I said, when you're using that first and last name on those envelopes, it's considered a legal name. And therefore, you're acting in public in the capacity of a legal representation and not a private representation. The legal representation is always public. Always.
So it's on your last name?
Yes, the surname.
Because my last name on my original birth certificate when I had it was in all caps, but my first name and middle name was not. Only the first letters was in capital letter, and then
Right,
I saw that as strange.
Well, that's
But now I got a new one, and so now it's in all caps.
Yeah, and see, when they do the conversion through the courts, it's a conversion of the last name only. They don't convert the first name, just the last name. And then they attach the Social Security number without dashes as an obligor number. And that's an unknown conversion. And had I known it, I would not have done it, because I knew I would not be organized under the laws to do so, or would have been compelled to do some research to make sure. Now that I know the difference, I cannot sign those documents in that capacity, knowing that that is a legal representation. If I'm going to make any legal representation and sign the first and last name, the legal representation is going to be according to the trust, and that would be by Benefactor, Keith Little, for the estate. Keith Orland Little, all uppercase. So as we continue on, says the other error is the theory that this rule is adopted from courts of equity, and that therefore one must have the beneficial or equitable interest in order to be the real party in interest. See, these people, these third-party debt collectors, are buying an interest in an account, hoping that you will give up that interest. And the clerk of courts are registering it in the court registry investment system for their interest. Again, all these trustees placing some kind of interest in the investment of an estate wherein they're denying the benefit to the real party in interest. And they're doing so either knowingly, unknowingly, willfully, intentfully, in error, whatever. I don't care. Once you give them notice, it's supposed to be an estoppel. But they refuse to recognize the notice and try to placate that they have an interest. That's bullshit. Who the fuck are you? The real party in interest cannot be the actual corporate name as they're presenting. It doesn't match the actual name of the bringer, the living soul. Whereas that corporate entity that is being brought against me, naming it as a defendant in that name, I am the only one that has a likewise name. LVNV as a third-party debt collector, LLC, is not a real party in interest and cannot be a real party in interest. There is no living soul named LVNV, LLC. You get where I'm going? On the basis of this latter assumption, some courts were under the impression that the statute gave totally new remedial right to persons having equitable interests. As, for example, the line of cases holding that an insurance company may sue a tortfeasor in a court of law in its own name when it is entitled to be subrogated to the rights of the insured. Now you see why I say everything is an insurance scheme. This is exactly what's happening. It's a tortfeasor, like I said, executor days on tort, in a court of law in its own name. The insurance company subrogates. What do you think the courts are doing? What do you think these third-party debt collectors? They're using a subrogation to sue, and they're not bringing the real party of interest into the court. On the plaintiff side, they're naming the very real party of interest in the suit, making a claim against that estate as if though he has no benefit of the estate, when he is in fact the benefactor that gave all the data elements to the estate. This is something that cannot be denied. Who are the benefactors that gave the data elements to LVNV LLC? See, they can't sue in their own name. They seem subconsciously to feel that a transformation analogous to that affected by the statute of uses had taken place, and that the holder of an equitable title was, by magic of this simple enactment, given all the remedial rights which formerly appertained to the holder of the legal title. See, you don't have to have any title to be holder of an equitable title. An equitable title only exists in use and possession. The legal title only exists in the legal forum, and it only pertains to entry and control. So once you have that legal title under entry and control and combine it with possession and use, you have the control of the suit, just like this is saying. Equity itself is trust law. Common law itself is contract law. Equity law was merged with common law, and that's the merger of trust law with contract. That's the insurance. That's the taxes. Those are prepaid expenses in order to enter into the venue and have any kind of control by some form of legal title, which is still a limited control. They seem subconsciously. That's unconscious. This error was made the more easy because of the statute enacted in nearly all the codes to the effect that there should be one form of action at law and in equity. And Federal Rules of Civil Procedure says there's one form of action, civil action, and therefore in that common law construction of contracts, the one form of action is civil action, and therefore it extends into equity. You must form it in a contract form to hold them to their contractual obligations under that trust to conserve the estate and no longer administrate the estate. Of course, if distinctions between law and equity had been abolished, then perhaps the holder of an equitable interest might have had additional remedial rights. But if so, he would not have acquired them by reason of the real party and interest statute. And it is very evident that the distinctions between law and equity have not been wiped out in toto. In other words, in totality. They are trying to, but they can't, because of the very fact that equity was merged with common law, telling us there is a distinct difference between them. And again, the merger of equity with common law was only to provide, through statutes, a remedial addition. So, it is worthy of note that several states have entirely receded from the position originally taken that one must have a beneficial interest in order to be a real party in interest. It is worthy of note that several states have entirely receded from the position originally taken that one must have a beneficial interest in order to be a real party in interest. Having thus stated the principles relied upon in interpreting this statute, we shall now take up some of the principal kinds of cases in which its meaning has been declared and examine the actual state of law. Assignee of chosen action. And before we go into that, anybody got any comments?
Was it the Erie Railway decision, Keith? Wasn't that like one of the key stepping stones to 1938?
Absolutely, because that was the thing that determined that military venue through easements. You understand that? Erie Railroad and the easements and the property they're able to consume of the private people, if they have to construct a railway, they have some kind of equitable interest through eminent domain as it relates to the populations and transportation, the commercial code. So they were actually using contracts under common law to enforce the equity inclusion, because otherwise they wouldn't have equitable remedies. They wouldn't have equitable rights or enforcement to obtain property to make it cheaper for the federal government to run a railroad straight through somebody's property rather than have to go miles around.
All right, so that hauled in commercial law into courts.
Correct. It allows us as private property owners, private property of land or any pertinence, to be able to enforce that pertinence against eminent domain. And if there isn't a remedy in that venue, for us to keep our private property, and that there is an eminent domain that would take it over, it could only be done by necessity, and that necessity must be done through recompensation. Again, the 6th and 7th Amendments. Yes. It is that privatization of eminent domain through equal use of the easement, which is a conservation easement. Go ahead, brother.
Yeah, so for other people who might get confused, the only way a person can be sued is by another person and not a corporation. So no business can sue a human. Only a human can sue a human under their terms and their jurisdiction.
Right, and that's why it's important to understand that when we get into these transactions, we understand that, so we know how to qualify that signature, so that they know that there's a contract in play. You're not subject to it, but you are a party participating in the trust as benefactor, and that is notice. The first duty in law is legal notice, that you're noticing and giving them notice on the instrument through a notation without recourse, without without prejudice and without recourse by benefactor Keith Little for the estate, the beneficiary. And that's legal notice. That's expressing the trust and noticing them that they're the trustee because you're the benefactor and they have a higher authority, meaning there's a grantee above them. That's plain language. So, in considering the effect of this statute on the matter of suing on a chosen action, it is not necessary to go into the substantive law concerning the assignability of choses. If choses in action were assignable in equity or at law before the codes, they still are. If they were not, they still are not. Again, it's important to understand the 9th and 10th Amendments here, in that we have rights that are not enumerated in the Constitution. Therefore, there is something greater, a fortiori, a greater truth, through number 9. And number 10 is showing that the United States has powers that are delegated, and those powers that are not delegated to the United States in the Constitution are therefore reserved to the states or the people. Wherein the problem with that is I think we actually need to rewrite that 10th one so the people comprehend that the power so delegated to Congress of the United States to lay and collect taxes, duties, imposts, and excises comes from the very people.
I agree. I thought of that too.
That way they understand that the only things left as relates to powers and the separation of powers is not just between the states and the United States, but that of the people, the United States, and the states, because it's truly the people that give that grant, the people that are the principal, and it is the United States that is the trustee, and it is the states through the very subsidiary contracting with the United States as a trustee makes them a co-trustee. Again, for the benefit of the people. It is perfectly clear that the same equitable defenses against the assigner may be set up as before. And remember, it's the assignment of a Social Security number to an individual, and it was the assignment of the legal name by the Social Security number, and so enumerated. They are the assignor, and you accept that as the assignee. So it's a defense against the assignor, again, the Social Security Administration, who assigns the Social Security number as a tax identification number, claiming you are a resident for income tax purposes, and you are residing in one of the states as a United States citizen who was born in the United States and then moved to one of the states. And that is a wrong implication. That is impossible, because nobody was born in the United States, and the record will reflect that. There is no evidence of anybody being born in the United States because there is no birth registration in the United States. Indeed, this has often been specifically provided in connection with the real party of interest statute. And perhaps the clearest illustration of the fact that this provision is purely procedural and changes no substantive law is found in the rule that where the law of another jurisdiction is applied, the real party in interest rule is not followed unless it is the law of the forum. So when you walk into those courts as an administrative forum, you're waiving personal jurisdiction by their assumption and your presumption. And it's not until you know these facts and can clarify them and make your special appearances through the mail or in private meetings with the information, the greater facts, the greater truths, giving them supplemental information and not making accusations, but just merely showing that there's an error being committed against the beneficiary, against the interest, both of the United States, the states, and the benefactors, merely for somebody else's private interest in a financial gain, proving misappropriation and misfeasance, malfeasance, breach of trust, breach of contract. There's so many.
Yeah, maladministration, and yeah, when it comes to the states, from what I had gathered, that since they're unionized with the government and all of the governors are part of the legislative branch, they're attached to that government. That actually, as if you're born in a state, even though the the states have created the all caps name in the birth certificate through the federal government.
Well, yeah, it's under 5 USC 301.
Yeah,
Minimum birth
so
registration requirements.
yeah, so if you are said to be born in a state, then therefore under the with the Social Security number, you are a U.S. citizen. You're not in the Republic of America. And people was learning this on, I found out on X, on other people who want this system. I don't want it. But yeah, they're people was waking up to this. You know,
Well,
John Bound on Alex Jones came out and reported about the all caps name finally. Finally, they put it on there, and the maritime law about how the birth canal, you know, how you are born into this and all that. So, and what the doctor is. And so that's finally coming out. So we're getting there.
yep. And one of the great things I like about Iowa, I'll show you here down below. But before I get to it, I put this, I copy pasted this in the comments section, the live comments, and it says in the simplest situation, that of a total beneficial assignment. Remember we talked about in toto earlier, in totality. Yeah, that of total beneficial assignment of a chosen action, the assignee is everywhere held to be the real party in interest. So again, it's your signature. And no matter how you qualify it, this here is still saying the assignee is everywhere held to be the real party in interest. Remember, this is trust law, folks. But it is submitted that the assignee was the real party in interest before the codes, or to say the least, he was a real party in interest before the codes. And I can't remember what case it is, but it's one that says the individual thus is not subject to the codes of his countrymen. See, these codes were all made before I was born. I'm not subject to them. I have to learn about them, see how they work, so I can see if they apply to me. And again, we have the merger of equity with common law, which is the merger of trust law with contract law, and therefore every thing I sign, I must express the trust either way. Otherwise, I could be considered in a contract position that I'm not. Or if I sign as a trustee in a contract position, I must be held to certain obligations to make the investment for the beneficiary. Simple trust law. As pointed out, or let's go back and read this because I mentioned Iowa. Iowa is one of my favorite setups because they, as I read these laws and stuff, they tell you a lot of information. And this is where a lot of the great decisions in trust law come from. Why, I don't know. It might be because Iowa is where the original Authors Guild was constructed in Des Moines, Iowa. I believe way back in 1950s, if not earlier. Illustration of this change of position are found in the decisions of Iowa. See Naylor versus Sharrow, 36 Iowa 232-36. Kansas, Stewart versus Price, 64 Kansas 191. Manley versus Park, 68 Kansas 400. Nebraska has some good ones too. Nebraska is the one that they had a federal or a state government official filed a suit against God. This is the story of Frank versus God. I've mentioned people mention it many times. I urge people to watch Frank versus God, and that story is based on a Nebraska senator, I believe, that went before the courts and issued that because it was not insured under an act of God, that he had to sue God under the same principle of suing under the real party in interest name. He had to sue the real party of cause. And since all the insurance company was claiming that it was an act of God, they couldn't cover him, so he had to sue God. Understand these concepts, people. Go ahead.
Yeah, when I heard that, I heard that Trump had ended the United States of America Incorporated, but then I heard that he put us under another corporation. And then come to find out, Klaus Schwab says that the system that America's ran under is going to be ended, and they're going to do a global thing. And so that's what Trump put us under, that new corporation that that NATO is creating or has created and going to enforce upon us.
Well, I don't know that anybody really comprehends that quite well. See, what Trump was fighting for in 2018 with the U.S. or with the Postal Service was the fact that the United States is paying a very large portion of the world debt. And what it is the gross domestic product. And United States is going forth with a very large percentage of their own gross domestic product and paying the taxes for several other nations that aren't able to pay those taxes to remain within the UN and its agreements under a charter. See, it's a pay-to-play club on the international level. And that's what we're dealing with. If you want to play, you got to pay. Well, learn how the system really works. Like I said, under money, unpaid balance of money or its equivalent. The other equivalent then is credit. So if you want to pay to play, you can still use credit rather than obligation or other security of the United States, merely by extending the credits, which they must and can only get from the people. The people are the true national treasures. They are the true things that bring forth the value in any nation. So as we continue on, and I dropped the link down there. I see we lost John. Don't know if he's just got bad reception or anything, wants to hop back up. But anybody else that wants to join the panel, please feel free. We're just going over real party of interest as it relates to contract and trust law and learning how, hopefully helping you learn how to separate the distinct differences so you know how to express it in the future, something we've not been taught. As pointed out by a recent writer, common law jurisdictions permit the assignee to control the suit, whereas administrative law doesn't. So it's telling us here again that the true law that you're supposed to be operating under is common law. And if under the assignee, you are being treated as a trustee, then you're the one that's under administrative law. But it says here, common law jurisdictions permit the assignee to control the suit, receive the proceeds, and in fact do practically everything any other plaintiff could do except use his own name. So again, by the assignment and authorization to assign, like I said, you're giving rights, titles, and interests to the name. They're saying you don't have the right to use the name except by their authorization. So when you sign it, their authorization, without educating you on how to properly express a trust, which would be a violation of Article 1 of the Bill of Rights, freedom of religion, freedom of speech, freedom of the press, freedom to assemble, and freedom to or right to petition the government for redress for misidentification. You cannot keep running with these assumptions, presuming that I will take upon that liability and not give me the ability to put off the liability through the proper qualified signature without prejudice, without recourse. That would be a blatant misprision of felony and your own act of altering or denying me to do something and forcing me to labor in a different way. And that's a 30-year sentence, I believe. Forced labor, abuse or threatened abuse of a law or legal system, civil, administrative, or criminal, for a purpose which it was not intended. You will learn to quit switching jurisdictions as personal service trustees, as that would prove your incompetence. If you don't learn it, It proves your incompetence in office, and you will be removed. Slowly but surely, one by one, we will come after you in our own name. Indeed, at common law, the assignee was for many purposes regarded as the actual plaintiff. Indeed, at common law, the assignee was for many purposes regarded as the actual plaintiff. And there he is. Yes, you're on it. Forced labor, forced labor. So anyway, we've come to the end of tonight's stream. I'll be back tomorrow night with the finish of this. We're about halfway through. And if you've got anything else to say on the way out, I just want to leave everybody with the important message here. Isaiah 54:17. Please read it until you understand it, that you have the ultimate responsibility and duty to rise up against the judgment. And in that judgment, that means you have to learn the different languages they're using to judge you. And remember that no tongue shall prosper against you. He's already promised that. That's the immutable promise. And that's what you have the right to seek counsel in. And that's that truth. So just bring forth the supplemental truths, which is the real party in interest is myself. There is no one else. I am that I am, and that estate pertains to me and not LVNV LLC, and they have no real interest at all. They are making a false claim upon which relief cannot be granted. This is so in all cases. Nobody has the right to sue in your name. Yet that is what they're doing, and is they're bringing a suit against you in that name and naming you as a defendant when in fact you are the actual plaintiff, because they have no real interest. They are violating the estate through executor des en tort because the person is in fact alive. You cannot just keep presuming his yea is your yea, or your yea is his yea. You cannot keep trying to control people through a fiction. It must stop. You got anything to say on the way out, brother?
No, I'm good, man. Great having a conversation with you and listening to it. I'm going to have to watch it again and start writing stuff down because, that Article 1, did you say Section 8 earlier?
Yeah. Yes, Article 1, Section 8. Read all those clauses.
Yeah, because on the regular internet, without going through what you go through, what I got from it was, where'd it go? It was saying something else. Here it is. Article 1, Section 8. The Congress shall have power to provide for a calling for the militia to execute the laws of the Union, to suppress insurrections and repel invasions. That's what I got out of Article 1, Section 8 that I only searched. So I don't know if that's just going through from another U.S. code, where it's like 18, and then you got your article, section, clause. So it didn't pull up. I can never get it to pull up the ones that you talk about. So I guess the only way I can see it is to go through that Cornell Institute website you go through.
You should be able to just pull up Article 1, Section 8 of the Constitution, and a site should come up. Let me see here. See if we put in, what was it? Article 1, Section 8.
Because I used Google and DuckDuckGo to find it, and it wouldn't pull up, others that you had talked about.
Okay, so when we see congress.gov, that's the one you want. Okay, when you go to these LII sections,
Cool.
or U.S. Senate, congress.gov or U.S. Senate. So I'll show you both. Constitution of the United States, annotated preamble, Section 1, Section 2, and you go up to section 8. So this is section 8. This would be clause 1. This is clause 2. This is clause 3. This is clause 4, 5, 6, 6. This is 5. This is 6. This is 7.
My only
Yes,
problem is being able to afford to get a computer so I could be able to print stuff out because I have an old tower. I guess it don't work to show on a computer screen no more. So, and it's got a different connection, and I got a connection for it to go to the screen, and it used to work, but I guess that part quit. So I can't even do all of what I want to do notices and because now I've got more info that'll make it more clearer on from you, and to help with Sovereign Living channel because you two are the ones that I've found that I'll listen to for sure, but yeah, I just it's crazy for me. I work at laying carpet and it does pay good, but there's hardly any work in this small city and town that I live in. Here in
see, that's part of the problem. See, folks, when we learn how to be the true extenders of credit, we can extend credit for local community projects. We do that through grants ourselves, just like the federal government does. And we can use the same instrumentality. And just like suing in the name of the real party of interest, we can grant grants in the name of the real party of interest as well. It's all an extension of credit from the estate. It's just a matter of how we propagate it through our understanding. And that's what I'm hoping to do here in the future, is show this community that if I have bonds that are worth all this money, as I placate, as been shown through the research I've said, then I don't have any real need for all those millions of dollars. But I'll be glad to give it out to the community and help forward some projects that would be helpful and benefit, letting them know that they are the beneficiaries, that this is a trust, and that we need to learn this stuff. And the best way to learn it, again, is when it comes to giving a man a fish, you feed him for a day. To teach him how to fish, you feed him for a lifetime. But the base principle is that once you learn how to fish, you have an obligation, a duty of notice to let everybody else know so that they too can help themselves.
Yeah, I say if you give a man a fish, then that man is dependent upon you forever. But if you teach a man to fish, then that man is independent and no longer needs to depend upon anyone but himself.
Correct. Yep. All right. Well, we are out, folks. And you guys know me. I love you. But I don't give a rat's ass whether you love me back. And that's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. See ya.